They have
Page number 44.
44 of
44 of the order part में क्या लिखी थी? Memo of their application I benefit method. Third order granted where to the applicant in schedule of them. Relevant observations made by the trial for page number 44.
page number
54. I am sorry.
54.
Page number 54.
Yes.
After about 10 lines, આરોપી તારીખ 20/5/18 લખત કરવામાં આવે છે. ત્યારબાદ તેઓના પોલીસ રિમાન્ડ પર મંજૂર કરવામાં હાલમાં તપાસ પૂર્ણ થઈ ગઈ છે. ચાર્જશીટ દાખલ કરવામાં આવે છે. નામનો ડીસી ઇમ્પોર્ટન્ટ અરજદાર આરોપીએ ગુનામાં ભજવેલ ભાગ જોવામાં આવે છે. તેઓ સતીશ કુંભાર નામના વ્યક્તિને શોધવા માટે ગોવા ગયેલા. કોમ્પ્યુટર હેકર બનાવી સામે શોધેલા. તેમજ તેઓ મુખ્ય આરોપી શૈલેષ ભટ્ટના સાથે કાબુ પડે અને અરજદાર આરોપીના એકાઉન્ટમાં 250 બીટકોઈન ટ્રાન્સફર કરવામાં હતા. તેથી જ ઓનલી એલિગેશન નંબર ટુ વેરી કોઈ વખત સાહેબ 250 કે કોઈ વખત 220 કે છે. ઈસીઆઈઆર માં ઇન્વેસ્ટિગેશનમાં આવ્યું અને 200 બીટકોઈન જે શૈલેષ ભટ્ટ મેન આરોપી છે who has received around 2200 bitcoin from the other entity that is the identity further 250 bitcoin ટ્રાન્સફર કરવામાં આવે જેવો આક્ષેપ છે. ચાર્જશીટના પેપર જોવામાં આવે તો અરજદાર આરોપીએ મનન શાહના વ્યક્તિને સંપર્ક કરેલો પરંતુ મનન શાહનાઓ નિવેદન જોતા તેઓની સાથે વાતચીત મુખ્ય આરોપી શૈલેષ ભટ્ટ દ્વારા કરવામાં આવેલી છે. નોટ ધી પ્રેઝન્ટ એપ્લિકન્ટ then I read further તે વખતે કાવતરું કરવામાં આવેલ હોય તેમ પ્રથમ દર્શનીય જણાવી આપેલું નથી. તો 120 ગોવા મુકામે અરજદાર આરોપી ગયેલા તેમાંની તે વાત માની લેવામાં આવે તો પણ તે વખતે સતીશ કુંભારે નામની વ્યક્તિની શોધખોળ ચાલતી હતી અને તે વખતે હાલની ફરિયાદમાં જણાવેલ ભોગ બનનારને અપનયન કરવાનો અને તેની પાસેથી પૈસા પડાવી લેવાનું કાવતરું ઘડાય હોય તેમ સ્પષ્ટ જણાવ્યું નથી. વધુમાં પિયુષ સાવલિયાના અપનયનમાં આ કામના અરજદાર આરોપીએ કોઈ ભાગ ભજવ્યો હોવાનું જણાવ્યું છે. That is the main crux of the matter. That is what the main allegation against the main accused along with the present applicant is as 120B. I read further. Page number 55. અરજદાર આરોપી આરોપી શૈલેષ ભટ્ટને બરોડાના શોરૂમ પાસે મૂકવા ગયેલ હોય તેવો કોઈ સ્પષ્ટ પુરાવો જણાતો નથી. ધવલ માવાણી નામની વ્યક્તિનો અપનયન કરવાનો આક્ષેપ છે. તે જોવામાં આવે તો તે વખતે હાલના અરજદાર આરોપી હાજર હોય તેમ જણાતું નથી. વધુમાં ધવલ માવાણીના અપનયનનો આક્ષેપ છે પરંતુ તે વ્યક્તિ ફરિયાદ દાખલ થઈ ત્યારથી આજે સુધી મળી આવેલ નથી. તેઓએ સ્વેચ્છાએ હાજર થઈ પોલીસ સમક્ષ નિવેદન આપેલ નથી. I may ignore the order part by the Honorable Supreme Court also that they have not arrested this person by saying that now company file we could not arrest. આપેલ નથી. હાલના અરજદાર આરોપીના એકાઉન્ટમાં 250 બીટકોઈન ટ્રાન્સફર કરવામાં આવેલ છે અને ત્યારબાદ 240 બીટકોઈન ટ્રાન્સફર થઈ ગયા છે. Even as per the investigation so far conducted by the PD also allegation is that આ જે 240 બીટકોઈન 250 બીટકોઈન હતા એમાંથી 20 બીટકોઈન સિવાય બાકીના બધા બીટકોઈન શૈલેષ ભટ્ટ મેન એક્યુઝ છે એના ઇન્સ્ટ્રક્શન પ્રમાણે ટ્રાન્સફર કરવામાં આવેલા. So that proceeds of crime is there through the present applicant. That is what the allegation is. I have benefited, I have procured and used my for own purpose. That is not the allegation. પછી બાકીના 20 ખાલી બીટકોઈન છે એમાંથી 300 જે illegal offense માં સીઝ કરેલા હતા. બાકીના જે બીટકોઈન હતા તે પ્રોવિઝન અટેચમેન્ટ ઓર્ડર પાસ થયો which is confirmed also by the concerned department against which 26 ની અપીલ છે ફાઇલ થઈ. ત્યારબાદ સીસીઆર 2019 માં રજીસ્ટર થયેલો. In the meantime 5 થી 6 વખતે I was called upon by issue સમસ્યા દરેક સમયમાં I decrement present cooperated with the investigation. I was not arrested. હવે જે ફર્ધર આ વાંચવામાં આવે તો બી એડિશનલ એલિગેશન અગેન્સ્ટ. હવે now read માનો સુપ્રીમ કોર્ટનો હુકમ છે પેજ નંબર 67 ઉપર છે. First order છે by it was released on April 8. એમાં પેરેગ્રાફ નંબર 3 માં એવું લખે છે having heard the complete for the party without going into the merits of the case and take the which is appropriate to release on April 8 for surrender to ground. હવે આ interim order હતો. then after read my lord to see the final order passed by the honorable assent for page number 1 in additional document which I have submitted.
Yes.
Sir, before reading page number 1, sir, page number 3 please. So, sir, double power is not a trigger at basic મોટર પાસથી બીજું offense કરતો double નથી પાવાની નામના વ્યક્તિની શોધખોળ ચાલુ છે એ બધું છે તે now the question was because what was Supreme Court also કે તમે બીજા આરોપીઓને કેમ અરેસ્ટ નથી કરે કારણ કે access still says it but no one was arrested till the day when I was arrested then no one was arrested therefore not this order was passed I read it page number 4 the state of Gujarat as well as the Directorate of Enforcement will explain as to why Dhawan Pawani has not been arrested and if he is given courage what effective steps have been taken in the past that to take him into custody that this order was passed on 22nd of January 2026 and well, ultimately the matter was kept on 26th of February 2026. Now, Maharaj, you see what order is passed on 26th of February, page number 12. On that day, the ASP who was appearing in that matter, he made a statement we could not arrest because now we have filed a complaint. And in view of the decision of the Honorable Court, when the complaint is filed, now we cannot arrest without that procedure which is laid down in the statement which is followed. Therefore, page number 1 here. હવે સર તેમાં પેરેગ્રાફ નંબર 2 માં હવે સર there is three lines in an interim order you want to the Supreme Court says without entering into the marriage whether it is right that interim order is passed through without entering into the marriage of the order થયો whether તેમાં અહીંયા પેરેગ્રાફ નંબર 2 આપતા જોજો having regard to the facts and circumstances of the case so the court has gone into the marriage also has considered the facts and circumstances of the case also and without expressing any opinion on my that is not that any observation affecting case of either party to the number of officers what is not expressing any opinion on my not assigning any reason so that આને એ લોકો ઇન્ટરપ્રિટ જે એફિડેવિટ લાસ્ટ કરીને એવી રીતના કરે છે કે આ જે having regard to the facts and circumstances of case છે ને એટલે સુપ્રીમ કોર્ટ has not entered into the merits of the matter અને that એફિડેવિટ નો લાભ ના આપવો that is the only contention there is that affidavit બીજું કઈ સ્ટેટમેન્ટ તો મેન એક્યુઝ which is a 2220 people કરેલા who was actively involved in that civil offense also the main accusation against whom allegation was made he is released on bail now only allegation against me is the મારી ઉપર allegation શું છે that reason to believe after zero against હવે ત્યાં ફરી મારા બેલ એપ્લિકેશનના મેમો ઉપર after zero reason to believe recorded at page number 28 એમાં સર રીમાં પોતે જ વાંચી જે રીતે બધા ટાઈમ નહીં જાય જે ચાર્જ છે એમાં ટોટલ 2251 વાત છે જે નેક્સ્ટ આરોપી પહેલી ઘટનાઓએ રિસીવ કરેલા હતા then next page number 32 પેરા 3.3 મેં જે વાત કરી એ નેરેટ કરી છે કે એનો સ્ટેટમેન્ટ રેકોર્ડ કરીને આટલી વસ્તુ એની કરેલી હતી now sir what is it says is at page number 35 paragraph number 2 આની બધું સબમિટ બીટકોઈન હતા એમાંથી બધું 40% ઘટના કેવો પ્રમાણે ટ્રાન્સફર જે 20 હતા એમાંથી એવા જે હતા એ અને બાકીના હતા એ પ્રોવિઝન એક્સપેન્સ પાસ કર્યો તો અસર મર્ડર થયો એટલે આજે મારા ઉપર જે ડિસિઝન હતા એ જે આટલા 240 બીટકોઈન પૂરા હતા બાકી અધરવાઇઝ આઈ એમ નોટ ઇન્વોલ્વ ઇન એની અધર ઓફેન્સ ધેર ઇઝ નો પાસ્ટ એક્ટિવિટી બીજું કોઈ મારા કોઈ પુરાવો નથી મારા પૂછું આટલું જે બીટકોઈનમાં જવાબ લખું એનો સાહેબ તો હિસાબ બની ગયો 260 માંથી 40 એનામાં ટ્રાન્સફર કરે છે એઝ પર ધી એલિગેશન ઓફ પીટીઆઈ મેં બીજા કોઈના એકાઉન્ટ ખોલે છે હું ઓપરેટ કરતો હતો એમાં જે રજીસ્ટ્રેશન સાથે કોના જે કોઈ કરે છે એનામાં ટ્રાન્સફર કરી દીધા છે યુએસડીટીમાં કન્વર્ટ કરીને એટલે આઈ એમ નોટ ધી બેનિફિશિયરી એઝ પર ધી એલિગેશન મેડ બાય ધી આના સિવાય બીજું કોઈ ફોર્મ તો મારા ઉપર એલિગેશન છે એટલે આનો એક્ઝામ્પલ કે therefore there is no further provision of the present applicant is required however I am still ready cooperate with the investigation since I am in custody even when I was not in custody I have already joined the investigation I did remain present on that is not the issue હવે આપણે પહેલી માટેનો ઓર્ડર જોજો not it is settled in view of the 16 of protect arrest warrant આપી my lord sir also considering number of cases that page number 5 paragraph number 9, page number 10.
Yes, you may read.
Yes, paragraph number 9 on page number 10 of my said additional document. Sort of number of pages my not have read, but I may not read that entire journal, but last 10 line and page number 11. You honorable court has said not what is required to be considered. It is very clear that the main activity is released on bail. The co-accused having played a lesser role is required to be released on bail by granting the benefit of parity. This is passed by my lord for a PCO 7 of page number 14. Not considering the very same ratio rule, the very same objection was made by the litigant at given point of time. કે જે મારો મેજર રોલ છે પેલામાં મેં રિઝાઇન અસાઇન નતા કર્યા. Even despite that, my lord have granted bail on the ground of parity by assigning reason at page number 18. 18 Roman 3 માં છે that parity નું ground consider કર્યું છે by considering these statements. He was the main person who was having person for this that government evidently he has responded this point which was received in his account. Out of 260, out of 2020, 260 was transferred and it was education arrangement. No further education. Therefore, when it is expected to release the applicant on any reason considered because at the same time I am also ready to further forget whenever they require my service, I will be there. I was there also since 2019 to 2020.
Yes.
Please.
Before coming to the allegation that has come up in the investigation, they have been relying upon two orders. Firstly, with respect to the order of grant of bail in schedule offence. For that, sir, I would submit that if your honorable court would refer to explanation 1 of section 44. I may be permitted to read. Explanation 1. For the removal of doubt, it is clarified that the jurisdiction of special court, while dealing with the offence under this act, during investigation, inquiry, or trial under the act, shall not be dependent upon any order passed in respect to the schedule offence. Sir, so considering that they have placed reliance upon the predicate offence order, it would not be consideration for the PMLA case. Secondly, sir, they have referred to the order of grant of bail to Shaleshwar. For that, sir, parity would not be applicable in the present case. Firstly, considering the fact that investigation for that accused has already been completed and he has been added as an accused in a prosecution complaint. But in this case, the investigation for this applicant is pending and it is going on, sir. And he has not been added in any prosecution complaint so far as the case is concerned. And as per the order of judgment of Supreme Court in Tarun Kumar case, the bail cannot, for even for seeking parity, he would have to make out his own case on the merits, and he would have to satisfy the twin conditions as applicable under section 45. Bail on parity cannot be considered as simpliciter. He would have to make out his own case that firstly that there are reasonable grounds of believing that he is not guilty of the offence.
Who is the main accused?
The main accused, his role would be not lesser than the main accuser.
Oh.
So I would come to the allegations for him also. I may be permitted to read the relevant portion of the judgment before coming to the allegations. I'll be providing.
Tarun Kumar is bail is not a principal.
Sir, just the relevance, relevant 152.
That role has to be made out.
Yes, sir.
But
so far as the role is concerned, I would come directly to that. Sir, so far as the nexus of this present applicant is concerned, so he was the one of the conspirators of kidnapping and extortion of cryptocurrency and cash to the tune of around 14.5 crores. Sir. He even made inquiries where
you don't want to, by explanation 44,
please,
you say the court will not consider any orders passed by the schedule. Now you still want to rely on the investigation of the schedule offence.
Sir, I am pointing out the investigation under the PML as well.
Yes. So under PML, when you contain on one hand, court
yes, sir. Because that was the allegation against which the ECR came to be registered. And so far as the investigation is concerned, his first statement came to be recorded in 2023, sir, in which he had, for an accusation of procedural crime, would say that he has admitted that he has received around 260 bitcoins from Shailesh Bhatt,
250, yes.
and out of which he has transferred around 20 bitcoins to his Binance wallet. And
So 20 he has transferred somewhere. He has dealt with.
yes, sir, yes,
240 he has returned back.
240 he claims to be that he has returned back.
So
But-
he claims, what have you investigated?
Sir, as per this, sir, we have sought the document from Binance Exchange Company, which has provided that there were around 200 bitcoins, which has been transferred from Shailesh Bhatt to the wallet of one person named Sunil Ratilal Bagh. And the role of present applicant was found to be connected to that transaction. When the search was carried out, it was found that this very applicant has created a wallet by using the KYC documentation of one person named Sunil Bagh. The person Sunil Ratilal Bagh has not operated or carried out any transaction from that wallet. It was this very applicant who has made the transaction out to the tune of around 200 bitcoins from that wallet, and that cryptocurrency was the same cryptocurrency that was extorted by Shailesh Bhatt, sir, in the initial.
But in 240 were transferred once again to Silas Bhatt.
Look, as per his claim, sir, it was transferred back to Shailesh Bhatt.
Can you verify and tell? Okay.
Sir, that is what I'm saying. Shailesh Bhatt, yes, transferred around 200 bitcoins to one wallet, which was in the name of Sunil Ratilal Bagh. And that same wallet, at the
Who transferred it?
Shailesh Bhatt.
It's Silas Bhatt who has.
Shailesh Bhatt had transferred to Sunil Ratilal Bagh's Binance account. And that same very wallet was in the control of this very applicant, sir. He has created a wallet using the KYC documents of a third person. He has thereafter diverted that same amount to one person named Sunil Sanjay Kotadia. That is where his diversion of layering of proceeds of crime would come into place, sir. It is not simply that he said, I have taken that amount and I have returned it back. He has further diverted it to some third person, sir. That is what investigation under PMLA has come out. And thereafter, he also converted that cryptocurrency into USDT. He has converted, sir, around 246 bitcoins into USDT, and additional 1 crore USDT into cryptocurrency. And all these transactions have been duly corroborated by the Binance Exchange wallet and as well as the blockchain record. The same stands substantiated from the same transactions.
So this is coming in your affidavit?
So yes, sir, it is there in the If the Honorable Court would refer to page number 11, from page number point number 3.5, sir, at page number 10 of my initial affidavit. Point 2.5 and para 4.1 and 4.3 as well, sir. All these details are there mentioned in the affidavit of the IO, sir. Sir, one of the argument that was raised in the bail application that the source, even if the Sunil Ratilal Bagh's Binance account is considered to be his own wallet, the source of the Bitcoin in that wallet was genuine. But if that had been so, sir, what was the purpose to route the same through a wallet of a third person, and why multiple transactions were carried out for the if the transactions were genuine, and why the same transactions were being carried out on the instruction of Shailesh Bhatt? So all these factors suggest that the present applicant was very much involved with the activity which fall within the definition of covered within the purview of Section 3. Sir. So in addition to this, his association has also been found to be in with one Dubai-based LLC with the name of RV General, whereby when initially he was confronted with the document, he could not give any explanation that what was the association and why the transactions were carried out with that Dubai-based LLC. In addition to this, he also acquired one immovable property through in the name of Messer Maruti Enterprises, which is his partnership firm, and the funds for the same have been provided or routed to him through Shailesh Bhatt, sir. So the POC has been again utilized by him for purchase of any movable property. And even sir, they have relied upon the order of this grant of bail in scheduled offence case, sir. But if the honorable court would see that after he was released on bail in the predicate case, sir, he has continued to involve and indulge in the activities for money laundering, because after the same order, he has created a wallet for diversion of funds. So it would, as per the twin condition, the second condition would not stand satisfied in this case, sir, because even if he is granted bail, he has done the same act after the grant of bail in the predicate case. There is likelihood that he would repeat the same offence. So all this forms part of the
Whatever
affidavit.
you are saying, as per your affidavit of the IO,
Sir,
he has received 246 Bitcoin from Silas Bhatt.
yes, sir. That was the initial investigation, and his, as per his statement in 2023. Sir.
And thereafter that, out of that 240 has been returned back.
240 has been
As
returned.
per your case,
Yes.
and 20 was with this accused,
With this.
10 in CID crimes.
Sir, this is
And
as
10.
per his statement under
Yes,
53. Yes.
Now, you are saying that 240 which were returned back, first is it was returned back to Silas Bhatt.
Yes.
Now your says that Silas Bhatt once again
Transferred to one wallet in his control.
the third wallet, which was in the name of Vada,
Wow.
and it
But
was
controlled and
controlled
operated
and-
by him, created by him only.
so your saying that it was 240 were with him only, that were managed by this accused only.
Managed by him.
Okay. And thereafter your investigation, what it has revealed? Something more.
Sir, one, he has converted the cryptocurrency into USDT, sir. This 246 and even additional 1 crore USDT, sir. In addition to that 246, additional 1 crore was also converted by him.
That is not here. It is further investigation or
That is in the investigation after the
this affidavit. So let your
That
argument-
is there in the at page number 9, sir. Point number D, sir.
point number.
D, E, and point number 6, sir. Page number 9 of the affidavit.
Internal page number 8 of affidavit shows on as the
Internal
overall
page number 9, sir.
percentage.
Internal page 9.
Internal page number 9 is the last page.
Sir, affidavit dated the 9th of February. It is 20 pages, sir. The first affidavit.
First page.
First affidavit. The point 3 number 4 and 3.5 would be relevant for the allegation which has come up in the PML investigation. Starting from page number 7 to page number 11, sir. And the conversion part would be there at page number 12 of the affidavit. Point number 4.2, sir. It is continuing on page number 12, starting from page number 11. And the purchase of property in the using the funds of the series of crime, it is at point number 3.5, page number 10, sub point 5, sir. Whereby he has used the POC for purchase of property.
So let your IO remain with the file.
Yes, sir. The investigation papers are also there. I'll replace it.
Let your
For a moment, page number, internal page number 8, row point 5, that is what the crux of the matter is, and that is what James was found during the investigation. That is the only allegation.
and ask him to the latest investigation for this accused.
Please, sir.
Is there anything further than the reply or not? So let him, but investigation is yet going on. Then now you have dealt with other 240 which were written. That is required to be
એટલે
asserted.
જ કહું છું. ના, સર, એવું કહું. એટલા માટે જ કહું છું, સર, રોમન પેજ નંબર 5 એ સાહેબ factual થોડું confusing એમને કહ્યું. એટલા માટે સાહેબ it is very clear from their affidavit only. સાહેબ જે 220 નું છે ને, એનું આપેલું છે રોમન 5 internal page number 8 સાહેબ ABCD માં આવી જાય છે. What is happened? સાહેબ ટોટલ જે 260 પ્રિન્ટો ટ્રાન્સફર કરેલા સાહેબ એટલે for a moment sir, internal page number 8, that is what they say on affidavit after that investigation સાહેબ આ 200 જે bitcoin છે એનું શું થયું એ સાહેબ આપેલું છે એમને. That is what they say કે સાહેબ શૈલેષ ભટ્ટના એકાઉન્ટમાંથી સુનિલ વાઘ નામના વ્યક્તિ હતા એનામાં bitcoin ટ્રાન્સફર થયા. હવે now it is the case of the prosecution કે એ સુનિલ વાઘનું જે એકાઉન્ટ હતું તે મેન્ટેન કરતા હતા પ્રેઝન્ટ એપ્લિકન્ટ. That is what the allegation is. અને પછી શૈલેષ ભટ્ટના કહેવા પ્રમાણે સુનિલ વાઘના એકાઉન્ટમાંથી એ જે bitcoin હતા એ USDT માં કન્વર્ટ કરીને સંજય કોટડિયાના એકાઉન્ટમાં ટ્રાન્સફર કર્યા જે શૈલેષ ભટ્ટના બીજા માણસ હતા. That is what the allegation is. એટલે આનો તાર મળી જાય છે. એવું તો છે જ નહીં સાહેબ, આ જે 200 bitcoin હતા એમાંના 1 બી રૂપિયા કન્વર્ટ કરીને યુઝ કર્યા હોય એ તો સાહેબ કેસ જ નથી. એટલે સાહેબ કહું છું એ કન્ફ્યુઝિંગ એટલે સાહેબ આમાં ક્લિયર થઈ જાય છે.
So for usage, I was also shown. For usage part, I was also shown that he has purchased the properties through the use of proceeds of crime. That is what I'm shown.
Yes.
So that was purchased after, as per the instruction, it was purchased after.
So let
આ bitcoin માંથી પૈસા ક્યાંય કન્વર્ટ થયા હોય અને યુઝ થયા હોય તો ઈડી નો બી ચેક કરી કેમ તો છે થઈ શકે. અને સંજય કોટડિયા જેનામાં ટ્રાન્સફર થયા નાઉ હી ઇઝ અરેસ્ટેડ. એટલે ફર્ધર સાહેબ આ bitcoin નું શું થયું તો સંજય કોટડિયાને બોલ્યું મારામાંથી તો ટ્રાન્સફર થઈ ગયા. એલિગેશન અગેન્સ્ટ ધ એપ્લિકન્ટ કે આ જે bitcoin હતા એ રૂટેડ શું થયા એકાઉન્ટ સુનિલ વાઘના જે એકાઉન્ટ એપ્લિકન્ટ મેન્ટેન કરતા હતા. Even શૈલેષ સુનિલ વાઘના એકાઉન્ટમાં બી સાહેબ આ bitcoin રહ્યા હોય કે કન્વર્ટ કરીને વિથડ્રો કર્યા હોય એવું તો કેસ જ નથી. એટલે સાહેબ કહું છું આ A2D છે ને સાહેબ એમાં એમને એફિડેવિટ ઉપર કીધું છે આવી જાય.
So in para 3.5, Roman 5, it is mentioned that he have used this POC only for purchase of another property. That is specifically mentioned in point 5.
સાહેબ એ પ્રોપર્ટી એમાં કઈ હોય તો સાહેબ ઇન્વેસ્ટિગેશન એમાં પછી પ્રોવિઝન એટેચમેન્ટ ઓર્ડર ફાઇલ પર પાસ થઈ ગયો તે એટેચમેન્ટ એપ્લિકેશન પછી
For him investigation is going on.
ભારત એકાઉન્ટમાં એ માત્ર 10 bitcoin હતા જે એ લોકો સીઝ કરેલા. બીજું તો કઈ છે જ નહીં.
So the provisional attachment ordering is referring to that is prior to the investigation for this accused. Against this accused, it is pending. It is going on.
you have attached his property to the tune of rupees.
Sir, for this attachment is pending, sir. No, sir. As
तो
of
CID crime में करेला है.
that is done with CID crime. The 10. I'll check with the IU, sir. I'll check.
10 બાકીના તમે બાકીના 10 છે ઈ તમે એટેચ કરેલા છે એવું કહો છો.
હા એ તો પ્રોવિઝન એટેચમેન્ટ ઓર્ડર પાસ જો એક કન્ફર્મ ઇન્ડિકેટ કર્યો એના તમે 26 ની અપીલ કરેલી છે એટલે મારા મેમોમાં બી કીધેલું. એટલે એક બી bitcoin ના પૈસા છે વિથડ્રો કર્યા હોય ને કે પરચેસ કર્યો પ્રોપર્ટી એવું તો કેસ બી નથી હોય છે સેના આધારે ફાઇલ હતી 26 આઈ ડોન્ટ નો પણ જે કેસ પીરિયડ છે એમાં તો એટલું જ છે. અને સાહેબ શૈલેષ ભટ્ટા જે 200 bitcoin નું બાકીનું આટલું બધું હતું 2000 bitcoin નું હતું એમાં બી એની પ્રોપર્ટીને જેવી રીતે એટેચ થઈ ગયું. હવે સાહેબ એફઆર પીએમ માં રિલીઝ કરશે હવે સાહેબ એક એટેચમેન્ટ પ્રોસીડિંગ છે which is part of provision of section 5 and 8 onward. હવે સાહેબ એ કમ્પ્લીટ થઈ ગયું એમાં ઇન્વેસ્ટિગેશન કમ્પ્લીટ થઈ ગયું એ એટેચ કરી દીધું પ્રોવિઝન એટેચમેન્ટ ઓર્ડર આફ્ટર ધ ઇન્વેસ્ટિગેશન વોટ કન્ફર્મ ઓલસો. હવે સાહેબ એ કન્ફર્મેશન ઓર્ડરના સામે 26 અપીલ બી નથી કરી એટલે એમાં તો ફર્ધર કઈ એટેચ કરવાનું છે જ નહીં.
Just let your IO remain. 12 or 13.
12.
बात कहते हैं
मारो सर दीदी
12 और 13. Ask him to remain present and what is the status of the latest, last status of the investigation for this second.
Yes.
એટલે સર એ તો ખાલી એક ચાર્ટ બની નાખી છે અધરવાઇઝ તો મારું માનશે નહીં રે એટલે જો ચાર્ટ
The parity ની વાત જરા આવતી હોય છે અને થોડા બે incident છે ત્યારે main accused છે તો અંદર clear છે proceed of it apply to both the small out the જે બે incident આની સામે જે છે there has nothing to do with any that gang or gang wars or working of any gangs. Both of those incidents are of personal in nature.
Order માટે